Hi comrades, yours Kayveeyes. In the recently held 63rd meeting of the Standing Committee meeting, for which the minutes was circulated on 25/2025, there was a discussion about allowing the benefits of favourable service litigation judgments to similarly placed employees even if passed by the apex court. The staff side demanded that the benefits of the judgment should be extended to the similarly situated officials, and all the officials should not be expected to approach the legal remedy for settlement of a common demand, and also the judgment which is common to everyone and maybe a judgment in rem. It was replied that the government in principle agrees with the extension of relief given by courts to similarly placed employees, where the judgment is in consonance with the government rules and policies. They have said it is principally agrees but not ready to implement it. But the matter needs to be examined on case-to-case basis, taking into account various factors like financial and administrative implications, impact on the concerned services. The consultation with nodal ministries and departments shall be taken place before taking any decision. Further, national litigation policy has been put in place to minimize the litigation. Only in the last word is the solace. National litigation policy has been put in place to minimize the litigation. But whether they have minimized the litigation? No. For each and every item, they are going on appeal. If it is a judgment delivered by the CAT, they are going for appeal in the High Court. Then they are going to Supreme Court. Thereafter review petition. Thereafter curative petition. Even after the curative petition, they don't want to implement the same and they are protracting. We have seen in the case of notional increment. We are recently seeing the cases of the commutation restoration amount after completion of 20 years. Lot of issues, they are common issues. Even in the case of Postal Department, the RTP cases, the erstwhile RTP cases, even recently we have discussed in another episode, the Delhi High Court has given judge all the important such judgments are in rem and it should be extended to all the similarly situated officials, irrespective of the fact whether they are approaching the court or not. But despite all these things, they are not implementing. The demand of the staff side JCM is very pertinent and very important one. But whereas the reply given by the government side is not at all acceptable. And if it is a common case, and if a decision is taken by the administrative department on one case, other cases, they need not wait for another court verdict or filing again in the SLP and other things. It should be implemented automatically to minimize the litigation as per the national litigation policy, which is the supreme document of the Government of India. With this, I am concluding. Thank you very much, comrade. Meet again.